Well, I rode pretty hard to get here before sunset. Looks like I just made it. But what I wanted to talk to you about from this location is, as an adult, I don't need a guardianship designation. That will be today's topic. And to understand that, we need to talk about what a guardianship is. A guardianship is a court-supervised procedure where property is held for an incapacitated person, whether they're incapacitated by age or some other infirmity. There is also a guardian of the person who makes the healthcare decisions for that individual. Now, in most instances for an adult, guardianship can be avoided with two simple documents: a designation of power of attorney and a designation of healthcare surrogate. By having those documents, you've set in motion who would manage your affairs if you could not for yourself. But even despite those documents, guardianship under certain circumstances can prove unavoidable. The two that I'm most familiar with is, one is third-party interference. It's Florida, there's a lot of older people, and therefore there's a lot of people waiting out there to take advantage of that fact. So these predators can often get themselves involved with an individual before the family finds out. Sometimes they'll replace existing powers of attorney with ones appointing themselves. They'll take them to the bank and there'll be withdrawals with no explanation. And that's an instance where you kind of have to take the checkbook away from the individual. So whether they had a power of attorney or not, guardianship is going to be necessary because now you need that court supervision. The other instance has to do mainly with dementia. A lot of times people who are suffering from dementia don't understand what's going on, as you might expect. So sometimes they'll get paranoid, and even if their family's trying to do the best for them, they don't understand. They may not cooperate in their own care, and again, you may need the court's authority to get them the care they need. So those are two instances that, with power of attorney and with healthcare surrogate, an individual still may need a guardianship designated. Now, family will always have preference of appointment in that guardianship, but it's not always clear who has preference. So if there's a disagreement amongst the family, again, we can be in a situation where the courts don't know exactly what to do and don't have clear guidance. The other instance may be, you may have a family member you definitely would not want to be your guardian because you don't want them managing your finances. That's another instance where it's important that you designate a guardian. So I'm going to say this is false. Every adult should designate a guardian for themselves, with very limited exceptions. And if you like this, please like and subscribe, and I will do more. Thank you so much.